On July 3rd, 2026, the Harris County, Texas, officer observed defendant driving a motor vehicle with a portable wireless comms device in his hand, confusing things. Officer did a traffic stop and defendant stated he wasn't on his phone when asked for driver's license and insurance.
Wait, he was pulled over for what?
For having a portable wireless comms device.
What the hell does that mean? Is he driving while black? Aren't you supposed to drive with hands-free devices if you're going to use a phone?
Not necessarily.
All right, I'm going to find no probable cause. Be careful. You know what I mean? If you're going to drive, just have a license, have insurance. Be careful. All right, buddy? Please.
That's it for now, Judge.
Okay. But we're waiting on what's his nuts, for the translator.
Yes.
Tills, Mills.
Here.
Yeah. What's the defendant's last name again?
Mohammed, page 34, it's a BB on it.
That's right. Mr. Mills, yeah. But he said that he's going to stay on it, correct?
I think he said he was gonna withdraw. He was gonna.
Oh, I'm thinking about Mr. Wood from yesterday. That's all.
Okay. Okay, he's gonna withdraw after that.
You ready? Judge, how long are we getting for jury selection today?
20 minutes? 30 at the max?
30.
Yeah.
Thank you. Yeah.
Hey, can you guys approach real quick? Do we have any issues that need to be talked about as far as pretrial issues, redactions, deletions, videos, 911s? Anything that you guys think? Is Ramona here? She's not there, is she? Okay, I guess we'll get it on the record, but yeah, she's not out here though. She's usually out here, but do you have anything that you want to talk about? And then we can put it on the record after. No? Okay, all right, great.
Yeah, he's not back there yet. I'll let Judge know and then so he can not Yeah, I'll let him know. Or maybe you could send it to you. Like just for the day. I'm going to say it.
Please. Good morning.
I'm Daniel Albert for
Yes.
Rosario.
Rosario?
Yes.
Custody judge, who was the largest one other day that's on probation for assault because they need to release.
I don't, no, I don't see it. Rosario?
No.
R-O?
Sorry.
Oh, Osorio.
It's Orio.
I'm not familiar with it.
So, Mr. Albert, tell me, what would you like to do? Where are we headed? Do you want me to, I guess all the courts are you going to represent him upstairs?
I don't, Your Honor.
But you're not going to.
Yeah, I don't do this, I'm not any appointed.
Do you want to stay on this case or do you want to withdraw? You tell me.
No, I don't want to stay on it.
Okay.
So,
Hey, he's going to file a motion to withdraw. If you don't mind appointing someone to Mr. Osorio.
Yes.
actually, I changed my mind. I'll keep it.
It's up to you. It's
Yeah,
whatever you want to do.
I'll keep it.
Um,
Can we, I'm in trial today and tomorrow. Can we do Friday if it gets rolled? Can we roll this to Friday?
That's what I was trying to tell him before he came out. Ms. Parker says that she can help out and she's done this before. With your permission, you tell her, hey, I can't make it down the trial. She'll come and approach for you. That way we can still stay.
Tomorrow, Parker?
Yeah.
Okay.
She does that.
so we can do tomorrow. We can do Thursday. If you're taking a break, you can come take a break in between and just, we're at your disposal.
Okay, we'll try tomorrow, see if I can come here earlier than my trial, sorry.
And then presumably he's felony court today? I mean, maybe tomorrow?
You do on mine too, right?
Because it says all 8/12.
Yes, Judge, just,
Right, obviously. Is he with us or is he upstairs?
Upstairs, felony today.
Okay, do you want to roll into tomorrow, Thursday or Friday? You tell me.
Friday's the best.
Okay.
So he's supposed to be back there with nobody talking to him for the next 3 days, 2 days. Is what I was saying, because he was on docket yesterday. He didn't make it up. Today, he might make it up.
He's in felony court.
Or, well, yeah, sorry, tomorrow.
How long has he been in custody now?
Yes.
You've spoken to him since he's been in custody, correct?
I'm not, Your Honor. I just found out about this literally last night.
Oh, did he just get arrested?
I think so.
Okay, yeah, then I can't let him sit without speaking to a lawyer for that long. Let me put him on for tomorrow. If you're not available, we can have Ms. Parker come and just, let him know at least, look, you've got a lawyer, your lawyer's in trial now. Do you have anything that you want me to do now? If not, we'll roll you till Friday, which is the day that you can be here.
Yes, Your
Is
Honor.
that cool?
Yes, Your Honor.
Okay, let's do that. I just don't want to forget about him and people end up, it's bad for you and I, Yeah, okay, let's do
Thank you,
that.
sir.
Good luck in trial too.
Yes.
Judge, he was spoken on meeting.
Hey, Ms. Albert, if for some reason you do not go, can you still make it tomorrow though? If you don't go to trial?
No, I am in trial currently.
Oh, you're current, okay,
Day
all
two.
right,
This is
got
day
it.
2 for trial.
Okay, all right,
Thank
good
you.
luck.
Yes.
Judge Ferraro even does that in felony.
Okay, put on for tomorrow then.
And Judge, are we just picking the jury terms?
Yeah.
and everything else?
Yeah.
Great.
Yeah. Start testimony tomorrow early, same time.
Okay.
You know, he's. Yeah.
I got Mr. Mills here. Do you mind bringing up Mr. Muhammad?
Saying.
Okay. Ms. Badawi,
Yes, Your Honor.
We're going to bring out the defendant here momentarily, if you don't mind translating for us.
Sure.
Good morning, Mr. Mills.
Good morning, Judge. How are you?
Pretty good, you?
Pretty good. Can't complain.
We're bringing him out momentarily.
Okay, cool.
Oh, okay.
Yeah.
Good morning, Mr. Mohammed.
Oh,
Here, Ustaz Muhammad.
Shh. We're here with your lawyer who is on Zoom.
احنا متواجدين اليوم مع المحامي والمحامي عبر شاشة الزوم.
It has come to my attention that you have picked up a new case.
وإنما إلى علمي أنك هناك قضية أخرى.
I ordered you not to have any contact with this complaining witness.
أنا
Not to...
عفواً.
Sorry, go ahead.
أنا طلبت منك عدم الاتصال بالمدعية.
And you've now picked up a felony violation of a protective order.
وأنت قد تم اتهامك بجناية أخرى وهي مخالفة أمر الحماية.
You have violated the conditions of this court.
أنت خالفت شروط هذه المحكمة.
I have therefore only one recourse, and that is to revoke both of your bonds that you have set here.
والحل الوحيد بالنسبة إلي أن ألغي شروط مخالفة شروط اللي هي الكفالة.
Your bond on the assault is set at $2,000.
كانت الكفالة بقيمة 2000.
I'm going to raise that to 5,003.
وسوف أتم رفعها إلى 5003.
And your $5,000 bond on the violation of a protective order, I'm going to double that as well to 10,003.
أيضا بالنسبة لمخالفة أمر الحماية سوف أضاعف هذه الكفالة إلى $10,000 و3.
I do not know if you planned on bonding out.
أنا لا أعلم إذا كنت تريد دفع الكفالة.
If you do, you will be required to wear a GPS monitor.
إذا تم دفعك للمخالفة عليك هناك جهاز تتبع عليك أن تضعه في قدميك.
You will be required not to consume alcohol or illegal drugs.
ممنوع عليك شرب الكحول أو أي مخدرات.
You are not to go within 1,000 feet of where she lives or where she works.
ممنوع عليك الاقتراب مسافة 1000 قدم من مكان عملها أو مكان سكنها.
When I mean no contact, I mean no contact of any kind.
وعندما أقول لا ليس هناك عليك الاتصال، لا اتصال بأي حال من الأحوال.
Phone calls, text messages, letters, or jail calls.
ممنوع عليك الاتصال لو تليفونيا أو عبر الرسائل المكتوبة أو الخطابات أو أي اتصالات عن طريق شخص آخر.
Do you understand these conditions?
هل تفهم هذه الشروط؟
Okay. Mr. Mills, did you want to talk with him in back, or did you want to just let him know out here?
I'll speak with him, Your Honor. I'll file a motion, but I'll withdraw it for now. I'll approach on it on a different date if that works.
Are you sure?
Yes, Your Honor. I'll have it resolved. I'll have that matter resolved in the next couple weeks or so, if that's okay.
Absolutely. The felony is set for 9/22.
Okay.
What do you want to set our cases to?
Well, I'm actually flying out of town today for a month to try a federal case in Los Angeles. So it starts on the 20th. Is it possible to move ours to like early October? If not, I can get coverage for
No,
9/22.
that's even farther than the felony court. And a lot of times people get lost and forgotten. So what I can do is I'll set you for the day after the felony court, which is
That's fine.
9/23. And then if need be, you can always Zoom again.
Okay.
That's a
That works. And
Wednesday.
if
But
not, I'll get coverage, Judge. It's no problem.
sure, of course.
Okay.
Just for what it's worth, let me see how old these cases are. Because obviously we will get to trial before the felony court.
Yes, Your Honor.
These cases are 115 days old. So by 180 days, we need to have a resolution.
Okay. So that's okay. 2 months. Okay, by October. Okay, Judge. I was trying to do the math in my head.
Do you have any discovery outstanding?
No, Judge, and I submitted actually an affidavit to the state, so I'll just need to speak with them to see how we want to go about resolving the case.
The only thing I'm going to counsel you, Mr. Mills, don't come here at 180 days and say that you want to withdraw. If you're going to withdraw, do it relatively quick. Don't wait 2-3 months and then say, oh, by the way, I want to withdraw. I'm not
Oh,
going to do
no,
it.
I'll have that matter resolved in the next week or so, Judge.
Yeah, that's
I don't
fine.
wait till the last minute as far as that.
Yeah. Okay. All right.
Okay, thank you,
Set you for
Judge.
that day. Okay.
All right, thank you, Judge.
So, Ms. Badawi, do you mind translating that we're going to set him for the day after his felony court?
Yes. أستاذ محمد هيتم تأجيل القضية لليوم اللي هو يلي يوم المحاكمة الخاصة بالجناية المرتكبة في هذا الأمر.
His lawyer is flying out to LA to try a federal case today.
المحامي لديك سوف يغادر إلى LA لوس أنجلوس لقضية أخرى يتابعها.
Does he have any questions?
عند حضرتك أي أسئلة؟
No.
No.
Okay. All right. We'll see you in a month.
شكرا، هنشوفك بعد شهر إن شاء الله.
Good luck. We still need him to sign condition. Yeah. All right. Thank you, Mr. Mills. Take care.
Hey, thank you, Judge.
Thank you, Your Honor. May I?
Thank you, Ms. Badawi. We're done.
Yeah, thank you.
The AM has increased to 5,000.
Correct. And I'm doing bail orders now.
Okay.
Yeah.
Hey, come on up. Hi,
On Long,
jail or bond?
Bond, Ashton Long.
Page 12.
Thanks. Okay,
Good. So, we're at the point of setting it for trial today, but I did receive yesterday, which I saw this morning for the first disclosure notice for the officer on this case. But it's just that one document that says, he got in trouble.
Okay.
I want the underlying file for that information, see what's.
why are we getting this so late? Long.
Yeah, this case will.
So, I mean, it's still 180 days. We'll set it. You're not going to get to trial 30 days, at least in 30 days. That should be sufficient time. You know,
Yes, can we just have some type of deadline in which I get this? I mean, in another court, I got.
What do you
2
mean?
days.
a
In which
deadline.
I get the file, the Brady information. I mean, we're 2 years into this now. Case from August 2024, they're telling me today for the first time.
Guys,
I'm double checking, Judge, because sometimes they get new disclosures, so I'm just double checking what the information says.
yeah, I mean, I'm not going to reward him for him taking flight for 2 years, I mean, it's time to set it.
Yeah, no, we're ready to set it, Judge. It's not that, it's just, this could be something.
Sure,
Really
you need to, if you're going to subpoena, you need to get it out today though. And just put a date certain of 10 days from today, that it needs to be here, any and all records regarding this.
Well, I would ask the state to get it from me, right? It's their witness. It's the cop.
No request, so we already reach out to our disclosure database, if there is any information that we have, documentation that we have from the agency to release anything additional we have for defense. I do see that it was uploaded in our system, to our file in 2024, so I'm not sure how discovery was being disclosed back then. But.
Has he had notice of it since
No,
2024?
Josh, that's the only thing, because when we became electronic, we have to release it on our system. So I know, I saw that was released yesterday to him, the real disclosure notice. If there's any additional documentation, we'll reach out to disclosure database and we'll provide that to them.
So can you send a subpoena today,
Yes, Judge.
10 days to be here,
Yes, Judge.
deuces tecum?
Yes, Judge.
And in 11 days, I'll reapproach if I don't have.
Yeah, but let's still have a tentative trial
I'll
date,
do that.
just because the case is 2 years old, so 30 days, let's see. August. September 22nd or 29.
22nd, I'm set in this court for another trial, but I can.
Do it.
whatever.
Yeah, might as well.
Okay.
All right, so jury trial that day, and then we'll be back in 10 days. Okay?
Thank you.
Yep.
Oh,
Also, hey, Mr. Alam, this case is, come up. Your case is 2 years old. It's time to either accept the plea bargain agreement or be done with this and we set this for trial. Once we go after the 10 days, you must be back here to go over all the evidence with your counsel here. That is your plea bargain deadline. You don't have to accept anything. If you don't, you will be continued to trial, but I will not accept any more plea bargains after that time. Do you understand? Your case is 2 years old and it's time to put this baby to bed and I'm not going to continue. This is the only trial setting that we're doing. Do you understand? Okay, so in 10 days, you need to be back here, go over the evidence with Mr. Alam, and then make a decision on whether you want to continue the trial or accept a plea bargain agreement. Do you have an offer on the case now?
there is a time served offer, yes, Judge.
Okay. All right, so can we do a 10-day setting from today? The appearance required for the defendant, and then we'll go from there. Okay, please. Okay, guys, we have a panel outside. We're about to bring jurors in. If you don't mind, please move to the sides. Please do not talk, do not use your cell phone. If you have to, just please go outside. Yeah, let's go. Ramona, are you ready? Okay. Is Miss Lovey here?
Yes, she's gonna back on me.
Got it, okay.
I'm just ashamed.
You gonna need me before we start? No? Okay.
All right, for the jury.
All ready and accounted? All right, please be seated, everybody. Good morning, ladies and gentlemen. Good morning, ladies and gentlemen. Much better. Happy Wednesday to everybody, middle of the week. I'm really so happy that you are here. Believe it or not, and I say this in every trial that we have, out of the 3 to 4 million people that we have that live in Harris County, probably 5% actually show up for jury duty. We really wanted to try this case yesterday, but there weren't enough jurors. So we had to continue it to today. So pat yourselves on the back. Thank you so much for coming. It's such an abysmal number. I mean, imagine if we didn't have jurors, it would be complete chaos. We wouldn't have jury trials. I mean, really, the justice system would stop. And so that's why we need you guys. Thank you so much for coming. I know it's a burden out of your time. I don't even want to be here. You know, I'd rather be, but here we are. My name is David Fleischer. I'm the judge of Harris County Criminal Court at Law Number 5. I don't know what you know about anything about the criminal justice system, so I'm going to start from the very beginning. So we have two types of charges in criminal charges in Texas. There are misdemeanors and there are felonies. Who knows what the difference is between the two? Anyone? If you don't mind, please raise your placard so we know what juror you are. Juror number 34.
Civil is usually family or dispute between people, whereas criminal is they did something bad and try for that.
Allegedly.
Allegedly.
Right. Within the criminal side of it, though, there's felonies and then there are misdemeanors. Anyone else know? Juror number 6.
Misdemeanors punishable by a year or less, felony greater than a year.
Very good. Wow. Good job. That is absolutely right. The difference between the two is how much time you're facing. I really like to sleep at night, so I let other people worry about felonies. Here, we just do misdemeanors. And so we're not going to really talk about felonies. We will just kind of focus on misdemeanors. Within the misdemeanor realm, there's all different types of charges. There's speeding, there's no insurance, there's assaults, there's DWIs, there's deadly conducts. So because of the different types of charges, we have to do sub-levels. There's 3 types of misdemeanors, A, B, and C. A is the worst, where you're facing up to a year and or a $4,000 fine. B, which is in the middle, you're facing up to 180 days and or a $2,000 fine. And Class C. Class C's are traffic tickets, like let's say speeding, no insurance, you fail to signal a lane change. Class C's, we do not deal here in the Criminal Justice Center. We leave the Class C's over to the municipal courts over there on Lubbock. And Harris County is so large, I mean, it's 2 to 3 hours from one part to the other, depending on traffic, that we have justice of the peace tucked in different parts of the city, whether it's Derry Ashford, whether it's in Webster, wherever it may be. So here we only focus on Class B and Class A misdemeanors that are punishable by up to 6 months or a year in jail. As you can see, we are here slated to have a trial. It is on a DWI. I don't think anyone disagrees with the law on DWI. They just might disagree on how it might be interpreted as to a specific person, place, time, thing, or whatnot. So I anticipate this trial will be 2 days, today and tomorrow. Number one, does everybody here speak English? Is there anyone here that does not? Believe it or not, I ask this question every single time, and we've had it before where someone gets selected and they don't speak. So it's okay. It's not a big deal. Does anyone not understand very well? Don't think they could sit? Okay. Number two, does anyone have tomorrow any kind of appointments that are absolutely unavoidable? Plane tickets, a doctor's appointment that's been months in the waiting? Anyone? Please tell me now. I don't want to wait till later. Anyone? Okay. We take this very seriously. And this is not rocket science. We're not asking you to do Pythagorean's theorem. I'm not asking anyone to split the atom. All I'm asking you to do is make a judgment call. You guys are old enough to know when you hear someone to know that the person knows what they're talking about or whether they're full of hot air. There are other choice words I'd like to say, but this is a family show. So your gut will always serve you best in nearly every situation. That's all we ask you to do. Listen, hear, look at evidence, and just make a judgment call. Is there anyone here that doesn't think that they would be able to do that? Okay. What we do now is we have two sets of lawyers here. I'm going to introduce both of them. I'm going to have both of them stand up just to make sure that, see if anyone knows these guys, any of the players in the game. After that, we will give each side around 30 minutes to ask you all kinds of questions. Believe it or not, not everybody may be the best juror for every single case. I know that DWIs are serious and it can impact people. And what we want you to do and hope that you will do is any kind of preconceived notions, lessons, life, just leave it at the door. All we want you to do is listen and make a judgment call. That's really it. Okay, state if you'd like to stand and please introduce yourselves.
Good morning, my name is unofficial. I am the one who's going to try this case.
Good morning, everyone. My name is Corinne Batista and I'm the chief of court.
Good morning, my name is Dan Sharp and I'm an intern with the state.
Anyone recognize these? Nope. Okay, you may be seated. Defense, you may please.
Good morning, my name is Marithia and I'm the defense attorney for Ms. Lovey.
Good morning, I'm Sean Syke. I also represent Ms. Lovey.
Anyone recognize any of these players? Anyone? Bueller? No. Okay. Well, without further ado, what we're going to do now is I'm going to turn it over to you guys and you may begin. You good?
Good morning.
Yeah, of course.
Well, good morning, everybody. Thank you for being here and appreciate it. My name is Sean again. I represent the state of Texas. I'm the prosecutor in this case. Is there anyone, again, I'm gonna ask ask, is there anyone who has been affected by a drunk driver, the family has been affected? Who think, yeah, that you're not a good juror for this case. And you were juror number 10, juror number 10. Anybody else that would want to tell us, okay, I don't think I'm right for this? Juror number 26, and may I ask, why you think that you wouldn't be the right juror for this? Family member affected by it, okay. All right, so, I'm just gonna go over a little bit of a housekeeping matter. How we're gonna go about this, we want you guys to be honest and there's no judgment here. We just wanna hear from you, your opinions. It's a judgment-free zone, I promise you, nobody's gonna, judge your opinion about anything. It's just we have to decide if you would be the right person for this jury and you would be impartial to both sides of the act. So please speak, please tell me your opinions, please answer questions. When you're answering your questions, do me a favor. It's kind of like an auction. You bring up your paddles and then I'll call on you. And that's the only way that my colleagues can get your answers down. So I really appreciate it. And don't leave me hanging here. I don't like to be the one talking the whole time. So I appreciate it if you participate. So I'm gonna go over a few things real quick and then we'll talk. The most important thing in a trial is that we gotta know there are two phases to the trial. There's the guilt, innocence phase, and there's the punishment phase. So the guilt, innocence phase, all we are deciding, all the jury is deciding is that did this person actually do what the state is alleging? Do I believe they did? That's all we're deciding. We're not thinking about, this was a situation, I feel for this person, I just think that they had a good, reason, there was special circumstances. Those can all come into effect and into your decision when we get to the punishment phase, where you decide, okay, this person, do they need help, do they need punishment, do they need whatever that is available to you. But for the first phase, I want you all to keep in mind that we are just going over elements. Do we need it? Is there guilty or not guilty? And that's it. As you can tell, this is a DWI case. And these are the elements that the state has to prove to you. That on or about October 1st, 2025 in Harris County, Texas, the defendant Chelsea Luggy unlawfully operated a motor vehicle in a public place while intoxicated. Now I have the intoxicated in red. Can somebody tell me why? Why are other elements, even though they're not in red? It's your number 3.
Because there's a limit to how much alcohol you can have, and it's whether it's over or under.
Okay, that's one thing. It's technical. There's more to discuss. Anybody else? Number 34.
I imagine that's because that's the thing that determines if they are guilty or not.
The more than one, exactly.
I was just gonna say, is it because all the other ones are common things?
That's a great point. The other ones are easier to go over, easier to prove or establish. And to point out one thing, because I'll have this told to me by jurors, why is this so repetitive? There are some questions that during the trial are gonna be repetitive, and it's just gonna feel like, you get it, you already said that, we already know what her name is, we already know where it was. But I want to apologize in advance. It's gonna be a little bit of repetitive, questions, and that's because we have to put that on record and establish it legally. But intoxicated, let's talk about intoxicated and what it means legally. When we think about intoxication on regular basis, on a daily basis, what do we think of? Anybody? Alcohol, journal number 3, 31. Anybody else? Want to venture a guess? On a daily basis, we get intoxicated, number 21.
Anything that would impair your judgment.
Impair your judgment, exactly. And a lot of times I come across people thinking, intoxicated, drunk, you're falling over, you probably throwing up, and you can't walk a straight line, you can't, talk or remember anything. But that's not what we're talking about when we're talking about intoxication in a legal setting. That could be a part of it, that could be there, but that's not what we have to prove. What we have to prove are these things, just one of these things. So I want you to also keep in mind only one. So we can prove somebody's intoxicated or was intoxicated at the time of driving by proving to you that they had a loss of normal use of their mental faculties. Loss of mental faculties are basically, your reaction time, your how fast are you to observe things? If you are given instructions, are you able to follow them? So it's not about you're just not comprehending anything. We all have seen people that have been, drunk and they remember everything, they have you might not even realize that they are, but it's just about reaction times, about, you ask them a question and they'll ask you, what was it again? Or you were explaining something to them and, they seem to want to hear it again, especially if it's a lot of steps, right? So, loss of normal physical faculties. What do you think about when you hear that? Anybody? Yeah, journal number 3.
The ability to walk or just move.
Okay. What else? Anybody else? That's one.
Fine motor skills.
But let me ask you this. Have you ever seen people that you felt like, okay, this person is intoxicated, I'm not getting in the car with you, but they could still walk?
Yeah.
Right, yeah, so, but that's part of it, it might be not walking the way they usually do, so that's the one. And journal number 14.
Maybe slurring their words.
I'm sorry.
Maybe slurring their words.
Slurring their words, correct, that's a very good clue that we look for. Journal number 4.
Just having like different than normal eye movements or loss of balance, the way you don't do it.
That's a really interesting one, and I'm very impressed that you know that. Because frankly, until I became a prosecutor, I didn't know about the eye movement thing. It's an involuntary movement of the eye, jerking of the eye that, on a normal basis, you don't know, and you can't control. So that's something that, me myself, I'm wondering until I actually saw it, and it's very interesting phenomenon that we will go over hopefully during the trial. Anybody else? Yes, you're number 5.
Reaction time.
Reaction time, exactly, reaction time is extremely important in driving. And the next one, easier, showing blood alcohol concentration of anything over 0.08. So if we show you any of those, we have proven intoxication. It doesn't have to be all 3. The jurors don't have to agree on which is it, but we can believe it's, to me, they prove loss of physical faculties. To me, they prove mental. It doesn't matter as long as you believe there was intoxication, and obviously due to the introduction of alcohol or drug or both. So again, this is what it would look like. You have all of those, guilty. You have all of these. The first one, mental faculties, second one, physical faculties, and their. So if you have these elements, these are the ones that they do. So why is it important? Why is it important to, again, as I was saying, there are people that you see, can walk and talk, and recall some really impressive, things when they're asking them. But when they are tested, they would qualify as legally intoxicated. Why do you think that is? Does anybody want to venture a guess? Nobody? Come on. Now, number 28.
Just focus and reaction time.
Focus on reaction time, that's great. And at the same time, what else are you doing? That goes to your mental faculties, right? And what else do you need? Your physical faculties too at the same time. So that's, driving is one of those tasks that you are really using everything. You're using your mental faculties, you're using your physical faculties, you're using your concentration. It takes a lot. Sometimes it becomes routine for us and we don't realize how much of our bodies, of our minds we use. We have to be able to follow instructions, follow the guidelines of driving. At the same time, look out for the cars around us. At the same time, remember the signal. All of that is a lot of steps that, again, you might be able to walk normally and talk normally, but to have all of it at the same time is the issue. And that's why you might see somebody that may look fine to the eye, but they really are impaired for the driving purpose. So who remembers the famous TikTok video, this is my first drink of the night, it's my last drink of the night. Okay, I want to show you this, since you all kind of look forward. Mix it up a little bit, see what you see. That's a bummer. I was working downstairs, I promise. So what I was just gonna show you, I don't know if you guys have seen it, it's just this video of a person at the beginning of the night having their first drink. They're speaking, it's my first, and then the last one is completely kind of look different. Eyes are red, kind of glossy, they're still talking, they're still, communicating. Some of them are dancing pretty fine, but in one video you see one of them, which is trying to eat a grape and it just falls. It's just those motor skills that we talk about. She actually looks better than the rest, but it's the fact that she can't get the grape into her mouth. Or this guy, this one is very interesting. He pours a bottle of water on himself, but. So this is a part I really need you guys to talk. Help me out here. Number one, who identifies with number one? Says, I don't drink at all. I cannot drive after a drink. I cannot drive after even one drink. You're number 14. You're number 34, 8, 9, and 10. Right? That
I remember this,
Well, number one, yeah, we're on number one.
sorry.
Oh, okay. So let's do number one more time, okay. Number one, 13, 24, 14, 34, 15, and 8. Now let's go to number 2. I do drink, but I wouldn't drive after even one drink. So number 9, 10, I'm gonna go in order, 12, 16, 17, 20, 22, 23, 26, 28, 30, 31, and 35. Now, I would say something about that, law commendable. The law unfortunately does not say that. You can have a drink and get behind the wheel, but you can't be intoxicated. Now, for those of you who are number 2, how do you feel about that? I want to hear about how you feel about it. Number 23.
It depends on your body mass and everything else that goes into how many drinks you have versus.
Okay, so you're saying, if I'm not wrong, you gotta know your body and what you can handle. Anybody else has a different reason?
For me, it's mostly just, I don't like getting behind if I know I haven't had anything, but I've seen people and I have friends who will drink 1 or 2 and they get behind, but they don't feel as effective, right? So,
Okay,
kind of goes.
yeah, you know, that's a good point you brought up, I just, okay, they don't feel as effective. Anybody else? That's a good point. Okay, so, is there anyone that has, this idea of, you know, I just hate somebody that would even take 1 or 2 drinks and decide to get behind the wheel, even though there is other options, and I could not possibly, be fair to them. Anybody that feels that way? Juror number 14, okay. So. Number 3, I think it's okay to drive after 1 or 2 drinks, but not more.
Is there a time period for 3 and 4, just before making a decision?
Technical question. Yeah, it will, from scientific point of view, but we'll get there unfortunately during trial and really we can't elaborate on it. Here we can't, we just want to get kind of a general feeling of how you feel about drinking and driving and what stage do you think, you know? You had 3, 4 drinks, I don't think you should risk it.
It's like, just baseline for all of you, just,
Yeah,
okay, I'll just.
let's say between a couple hours.
Okay.
Yeah. So, 1 or 2, no more than 3. Yes.
I would say it was 1 or 2, but it's still on that 1 or 2 drinks, it still depends on the individual.
Depends on the individual.
On their body, you know, some people
Yeah.
could on that, on 1 or 2, and some people can't.
Yeah.
So it's gonna be based on your body and how it consumes it, so everybody's body is different.
Correct. That's juror number 5. Anybody else? Juror number 18, 19. Oh, yes, 3. All right, we're gonna go from the beginning. 1, 2, 6, 7, 18, 19, 21, 25, 27, 29, and 32. Okay, and is there anybody that feels like 3, 4 drinks or, you know, doesn't matter how much you drink. If you know your body, you know you're fine, it's fine. That's the other thing. 30.
It's a couple hours, so.
No, but forget about the hours, you know, you just think, it's fine, as long as I know my body, I know I'm fine, I'll get behind me.
I'm not gonna do it after 3 drinks in an hour, but if it's 3 hours.
Let's say you had a device, and the device shows you you're above 0.08. But you feel like, so this is the one I was gonna talk about, but you feel like, you know what, I said this much to do, I said, I'm fine, I can do better, I can, backflip here. I can do anything, I'm just fine. Who feels like it's okay to get behind the wheel in that situation? Anybody? So that's the thing when we talk about tolerance, you're right, when a lot of people have high tolerances due to the fact that they drink more often or metabolism or whatever it may be. But at the end of the day, there's a reason that we have that standard of 0.08 and above, because again, we're not talking about drunk. We may feel like we're fine, but it's different when it comes down to driving. I'll give you an example, so you know.
5 minutes.
I have an accent. I'm sure you all hear it. In my head, I don't hear it. I don't know if if that makes any sense, but I'm always shocked when people are like, "Oh, you have an accent. Where are you from?" I'm like, I don't hear it. So that's the thing, but it doesn't take away from the fact that I have an accent. So that's what we're talking about. Burden of proof is on the state, obviously, beyond a reasonable doubt. I know that you guys have tried that ad nauseum in TV shows. We have to show you beyond a reasonable doubt, prove to you every element that we talk about of the crime. What they did not, the legislator decided they're not gonna give us a definition of beyond a reasonable doubt. So what we have is what it's not. Beyond a reasonable doubt is not beyond all doubt. It's not beyond a shadow of a doubt. It's not beyond, it's not 100% or any type of percentage to it. So it's basically just, do I have a doubt that they meet at any of these elements, and is that doubt reasonable? Does that doubt make sense? And let's go to the visual example. I'm a visual person. If I showed you this and I told you this is a picture of 2 giraffes, have I proven to you that this is a picture of 2 giraffes beyond a reasonable doubt?
No.
Right? Now let's say I show you this. Have I proven to you that this is a picture of 2 giraffes?
Yeah.
I mean, we have missing pieces. You might, if you have a doubt, yeah, you could. Is it reasonable to have doubts? No. And again, it goes to the elements. Now, if I told you, or somebody gets up and says, well, but you don't see the tongue. I don't know if he has a tongue or not, but that's not an element. It doesn't matter. Yes, I could not prove to you beyond a reasonable doubt that the giraffe's tongue is not out. But does that matter? Really, no, because I have to prove to you that the giraffe is there or they're giraffes. That's it. The tongue we get into in the other phase of trial, right? What type of evidence do you all expect? What's evidence? Testimony, that's one of the most important things. I mean, there are other evidence that is pretty much, known to everybody, maybe blood or breath or, scientific stuff. But the one thing that's important to keep in mind, testimony is evidence. Anybody who gets up there and testifies, what comes out of their mouth is evidence. But as a juror, you decide, do I believe this evidence? Is this evidence credible to me or it's not? Right, so. Witness credibility, this is probably my last ones. The law says you gotta look at everybody, every witness that gets up there, you gotta look at them, with the same eye. Is there anyone who would give more weight to a testimony of an officer as opposed to a testimony of a regular person, just because they're a police officer? Anybody? Is there anybody that on the reverse side? I have no trust for police officers. Anything comes out of their mouth, I don't believe it. Is there anyone that feels that way? Don't be shy, always judging, there's no police officers.
1 minute.
Right, no way. Oh, so last chance, do you guys have any questions for me? That I haven't, that you feel like, okay, I should cover this or that. Yes.
So is the purpose to determine whether it happened and then punishment or?
Yes.
Okay.
So first phase of trial, we are only focusing on, did it happen? Did the state prove to me all those elements beyond a reasonable doubt? That's all that you can take into account. Now, it doesn't mean that there aren't other things that will be coming at you, but you have to focus on elements, kind of like you're an engineer. Do they fit these pieces? Do they fit? Do they make sense? Did they prove it to me? And that's it. I'm not taking anything else into consideration. So that's the main goal. Anyway, that's number 19.
I guess the main definition would be to like one of the check marks about like mental impairment, physical impairment, like would that categorize something like I said, falling asleep behind the wheel, considered as a DWI?
If there is, if it's proven that alcohol was introduced to the body, that could be a very good proof. Yes, falling asleep, not being able to, stay awake, that's a complete loss of mental faculty, correct, and physical. So that's definitely, there are cases like that where it's yeah, 100%. Number 6.
What you were talking about before this about trusting law enforcement.
Yes.
I would lean more toward trusting law enforcement than.
Gotcha. Just
from my experience.
On a personal level, but would you be able to, even though you feel that way, would you be able to stay fair and impartial?
Yes.
Okay,
All right, time.
all right, well, thank you so much, thank you for hearing me, I'm sorry if I bore you. It's the nature of the beast. Sorry, Judge, the court doesn't like math.
Yeah, that's right. Don't like Max.
Yeah.
We're not gonna worry about it, because the internet just went out. All right, good morning again. My name is Marcia Donaldson, and my co-counsel is Attorney Sykes, and we represent Ms. Lovey. So before we start, I'm gonna ask you a question, and I'm gonna give you a hat first. The easiest way to go home without having to sit over here is by talking, right? Because the more we talk, the more we know, and you might shock yourself, right? But if you don't say anything, we don't know anything about you, so you end up over there, right? Alright, so what weighs pounds? What weighs more, a pound of bricks or a pound of feathers? Well, I heard brick feathers. So I'm gonna say number 19, bricks or feathers?
They're the same thing.
Okay, does anybody disagree with your number 19? Number 14, oh, no, I'm sorry, I just heard you say that it's the same weight. Yes, okay. So that means that a feather has at least some weight to it, right? Okay, cool. So I'm glad we can all agree to that. So when I ask you questions and you're not sure, you might want to say, I think so, or I don't think so. I want you to go ahead and put that feather's weight on it and give me a definite yes or a definite no, okay? Now, no question is a bad question. No answer is a wrong answer. We're just asking questions because we want to get your opinion on certain things. Just so we can figure out if you're a good juror for this case. If you're not, you'll probably get called down here again this summer, okay? So no worries. All right, so can anybody tell me what a charging instrument is? I've never been a teacher, but today, juror number 2, what's a charging instrument?
A charging instrument, like a plug for a phone?
Well, I want to, you have lost. Everybody want to help her out?
Something for prepared.
Okay, and what juror number are you? Okay, really quick, whenever you answer a question, go ahead and put your juror card number up because Ms. Ramona here is taking down what you are saying and she has to know who's speaking, okay? So he said it's something that the court prepares. And so it's not evidence of anything, it's just saying like, hey, we think the person might have done this, but there's no evidence of guilt or anything like that, okay? Do we understand that?
Yes.
Okay, so who here says, I get it, a charging instrument is simply a sheet of paper. But because Ms. Lovey is sitting here, she must have done something. Who feels like that? Juror number 33. Okay. Juror number 32, you like?
Done something, sure, it's done something, she's here.
Okay, so if you had to make a decision right now about whether she was innocent or guilty, what would your verdict be?
No idea, I haven't heard any of it.
Okay, so if you haven't heard anything, then what would the verdict be?
Yes.
Correct, juror number 31.
Innocent to proven guilty.
Well, we like to say innocent unless proven guilty, right? Because until it's supposed to, they're going to be found guilty. You don't want that, right? All right. Now let's talk a bit about technicalities. The state showed you a list of elements that they had to prove, right? And one element that has to be proven in every case is where the incident happened, okay? And so let's say juror number 3, right here in the black, slap juror number 19 because he's wearing a red shirt, right? And he gets on camera and he's like, hey, I'm juror number 3, red, not my favorite color. Juror number 19 showed up today with a red shirt, so he got slapped, right? But the state put on no evidence telling you that it happened in Harris County. What should the verdict be? Juror number, you kind of smiling, so juror number 5, what would your verdict be?
I feel so.
Okay, does anybody disagree with juror number 5? Is there anyone that says, you know, like, if I saw it on camera and he admitted to it, but the state just didn't tell me it happened in Harris County, it's gonna be guilty for me because it's a technicality. Does anybody feel that way? Juror number 14. Juror number 6. Number 4, you're like,
I'm a little confused, maybe.
okay,
I don't remember seeing Harris County as an element, but like a public place.
well, we're in Harris County.
Yeah.
And so if we're in this court, the offense will have to happen in Harris County in order for this court to have jurisdiction on it, right?
Yeah.
So you can't go do something in California and then think that you're gonna come here and get prosecuted for, right? It would have to be in California. So the state would have to show you that this court even has jurisdiction to prosecute this case, right? And then make some hearing. Okay, cool. So if they didn't do that, would you be able to find someone not guilty?
No. Or find someone not guilty, I mean, yes.
Okay, perfect. So if they didn't prove it, it's a not guilty. I just want to make sure we're clear.
Yeah.
Okay, cool. Juror number 14.
Now I understand what you're asking.
If you can't prove it. Right. Because the state is required to prove every element beyond a reasonable doubt, right? You don't get to say, well, I'm in Harris County and if the judge is sitting up here and it says Harris County when I walk in, so it must have happened in Harris County. You don't get to jump to those conclusions, right? The state has to prove every single thing to you beyond a reasonable doubt. Do you understand that? All right. And then I just want to circle back really quick on something that the state asked. They asked if anybody had ever been a victim of DWI or had a family member that had, and I had juror number 10. Would your experience or your family member's experience affect your ability to be fair in this type of case? Okay, so go ahead and put that judge's weight on it and give me a yes or no. Yes. Understood. And then I had juror number 26. Same thing. Would your experience with this type of situation affect your ability to be fair in this type of case?
No.
Understood. Okay. All right, let's talk about the Fifth Amendment. Juror number 6. What is the Fifth Amendment?
The right to not incriminate yourself.
Understood. Anybody disagree with that? No? All right, so we all understand that we have a right to remain silent. Okay, what's your card number? Juror number 29. What are some reasons that a person might not want to testify?
Harassment.
Okay. What's your card number? If you look at me, I'm gonna call it.
Oh.
What's your card number? Juror number 21. What is the reason that a person might not want to testify? Sure. Any other reasons we can think that a person might choose not to testify? Juror number 18.
Not everyone's a good public speaker and they may feel pressured and they may feel like they say something that isn't true, even though they don't do that.
Right, so we can agree that there are a number of reasons that people choose not to testify, right? Now, who here says, I get it, I get the nervousness, but if this were me and I was sitting over there, I would want to tell my side of the story. Who feels that way? Juror number 14, juror number 4, juror number 6. And y'all understand that she has a Fifth Amendment right not to incriminate herself, right? She does not have to testify. So if the state put on their case, right, but you feel like they did not prove every element beyond a reasonable doubt, and for some reason we decided that we were not going to put on the defense, and you never hear from her, and you never hear from us, what would your verdict be, juror number 14? Okay, all right, so you understand to get this done right. Understood. All right, let's talk about drinking versus intoxication. Has anyone ever gone out for like dinner and had a beer or a glass of wine, a margarita with tahini on the rim, light ice, and then drove home? Okay. Juror number 17, why did you drive? Why did you drive home after having the drink?
No, I don't have a full beer,
Okay.
like that or something like that.
I would drink all of my margaritas. Juror number 20. Did you have your car raised? No. Who else has one and drive? I need to. Okay. Juror number. Policy. Juror number 23. Why did you drive home?
Because it was one and I get home.
Okay.
Local place.
So is it fair to say that consuming alcohol doesn't automatically equal intoxication? Do we agree with that? Okay, and we also understand that having a drink and then driving is not against the law, but driving while intoxicated is what is against the law.
Right.
Okay. When you hear the phrase driving while intoxicated, what part of that phrase stands out to you? Your number, you have to be intoxicated. Mhm. When would you have to be intoxicated to be breaking the law?
When you either demonstrate you are physically impaired, demonstrating that you're impaired, or demonstrate by a test that you fill out and you lose over a point of work.
Okay, anybody want to help them on when?
When you're driving.
Say it again.
When you're driving.
When? Wow, okay, yeah, I kind of battled with asking that question because I wasn't sure, but y'all got it, while driving, got it, okay. And if I told you that it was 95 degrees outside at 3 p.m., could you tell me what the temperature was at 10 a.m.? Why not? Number 8.
It's gonna give us temperature that was outside of 3 p.m.
Okay. Anybody else? Would you be able to tell me the temperature? 3?
No, because there's a lot of factors that could have changed the temperature in that time.
Okay. All right, we're gonna move on. Is there anyone that believes that people should have the right to refuse tests or questions from officers? If you agree with that statement, go ahead and raise your card. Do you believe that people should have the right to refuse tests or questions from an officer? Juror number 25, why do you feel that way?
Sometimes, just from my background, some officers try to dig a little bit, almost self-eliminate person to function. And then it opens up almost anything.
Okay. Number 31. Hey, Mr. Officer. Do you believe that people should be able to refuse tests or questions from an officer? That's what we said, y'all. What are your thoughts about someone who initially agrees to cooperate with law enforcement, but then later decide that they no longer want to continue cooperating? You're number 23. Okay, anybody else want to add on to that? Number 3?
You shouldn't need a reason to exercise your rights.
Okay. Other than guilt, what are other reasons that someone might choose not to cooperate with officers? You look at me, what's your card number? Jury number 33.
They just might be scared. It's, you don't wanna, like, back to the my you don't wanna say something that could be used later on for you. And it's just like if you're at the moment.
Right, so. Here, I got pulled over this morning. He gave me a warning though. Jury number 12, what is the reason that a person might choose not to cooperate with an officer?
Current environment, get all sorts of.
Understood. What about you, number 15? Reasons a person might not want to cooperate with officers?
I think I need to cooperate.
Okay, so you feel like anytime an officer tells you to do anything, you should cooperate? So if he tells you to jump off a bridge or jump. So we can agree that there might be instances where people might choose not to cooperate, right? So, okay, and then let me ask you this. Although you feel that way, do you feel like that should be the case for everyone else?
I can't hear you.
So,
Can you repeat what you said?
yeah. I live in Hyde, so I'm innocent and I can cooperate. Okay.
Okay. Understood. Does anybody else feel like you're number 15? I don't have anything to hide, I'm innocent, so I can cooperate without issue. Juror number 28, 14, 24, 25, 34, you like it. It depends on the day. Yeah, okay, got it. Right. All right, I'm gonna pick on some engineers. Juror number 17. If you hear a scientific number, like a blood alcohol is gold, do you feel like that's automatically reliable?
Depends
Yes, okay, depends on.
how it came up with the number. How they worked as a group that came up with the number.
Got another engineer sitting right next to it. Juror number 18. What happens when procedures aren't followed? Can results be trusted?
Probably not.
Probably, or you gonna put a feeling weight
I
on it?
mean, I think it depends what the
Okay, I can take it.
discrepancy is, but yeah, I would certainly catch that.
Okay. Crazy thing is, juror number 19 is an engineer too. So if you learn that safeguards weren't followed in testing, would that matter to you?
I think it was for sure. The procedures are, there for a reason, to do it the right way, then. Yeah, let's say that needs to be investigated.
Okay. We're gonna switch gears just a little bit. Who's got emotional during a stressful situation? Okay. When you got emotional, have you been drinking? No? I'm like, let me think. Probably, right? Anybody ever just get in the shower sometimes and just cry? I know, I don't even know how to cry, but it feels like I need to cry, right? So, do we think that being stopped by the police can make somebody emotional or nervous? Yes, okay. Do we think that that emotion can increase as the stressfulness of that situation increases? Okay. Do we think that sometimes when we are in certain situations that anger, fear, or embarrassment or frustration could affect the way that we speak or behave?
Yes.
Okay. And then juror number 7. Does being emotional alone tell you whether someone has lost their mental or physical faculty?
No.
Okay. Well, that was done, y'all. All right, let's talk about impairment. If someone had a very high BAC or blood alcohol levels, unless you whoever sneezed, how would you expect them to look? Juror number 5. Blood alcohol level, how would you expect them to look?
Looking fair, red eyes, and balance, and unequilibrium and all that.
I have terrible allergies, and sometimes my eyes are red and itchy. And so if I was here right now with red itchy eyes, but talking to you the way, I'm not like, well, would you think I was intoxicated? I was worried. You might say that. But would you think I was intoxicated and my eyes are red right now because I have a really bad allergy?
No, not with, it would have to be other signs besides your red eyes.
Okay, so we can agree that there are other reasons somebody's eyes might be red or glossy or, okay. Juror number 6, do you think that someone might have a greater tolerance to alcohol? If so, why?
Yes. Maybe how much they weigh, how much they drink, whether they eat or not eaten, they've got sleep, there's a lot of factors that go into person A versus B drinking the same alcohol. These facts can be changed.
I agree with that. You're looking at me, what's your juror number? Yeah, juror number 12. What are some reasons a person might have slurred speech other than alcohol?
Ulcer mouth,
number in the day. You know. Underwritten, swear.
Okay, you're number 13, your eyes are right. Do you have anything you want to add to that?
Natural speech impediments, medication, excellent. Slur speech.
You're number 16. What are some reasons that a person might be unsteady when they walk other than conventions? Do you want to answer that? You're number 17? And I'm gonna go to what think you're number 20. What are some characteristics of physical impairment? Okay, here, I'm sorry. If you're with the inability to walk, staying awake. Okay, and then your number 22. If the behavior doesn't match the number, would that raise questions for you?
No.
Okay, does anybody agree with your number 22? So if the behavior doesn't match, so say for instance, if somebody had a BAC of like 0.30, but they ride in here on the motorcycle, would you have questions?
Yes.
Okay. And then your number 27. Does alcohol affect people immediately or does it change over time?
Change.
Okay. What are your thoughts on that same thing? Your number 28.
Yeah, it changes over time.
Okay. Your number 30. If a test is taken later, is it possible that the results reflect a different time than when someone was driving? It was a lot of words. Okay. All right. It was a lot of words in this question. Okay. All right. So at some point, my attorney Sykes' ability to stand in that gap for Miss Lovey goes away, and it becomes your job, right? If you end up on this jury to stand in that gap. And we like leaders, okay? And so we want people who are going to stand on their verdict, and they're not going to be easily swayed by what everyone else is saying if they truly believe that our client is not guilty. Is there anyone in here that says, you know what? I am not in the mood to be a leader this week? No? Great, with that, I'm done.
All right, thank you so much.
Thank you.
Lori, if you want to come up real quick? Thanks. 30 minutes too much. 30 minutes too much.
No. No, 30 was good.
Think so?
20, I always want to. Yes. That's what I was saying. Judge.
Ready?
Yes.
Okay. Guys, let me say, I think that we have at least 2 to 3 for cause that I see.
Yes.
First one is probably number 10.
Yes, sir.
Okay.
Can agree.
I was thinking about 15 as well. Because I didn't know whether she was going to be able to really. It seemed like there was, but I don't know, right? Maybe communication issues, and if it gets maybe a little bit.
Yes, sir.
Out of an abundance of caution, and then number 33. 33 was that. She's already, just by virtue of being here. Okay, state, do you have any? Which one is that? The 10, 11, 12, 13, 14. Yeah, okay, so. Yeah, I didn't see anyone else on. Thirty-two is the general. Glasses. Oh, wait, do you have anyone on the first one? No. So it's just 32. Okay, then we'll just kick it then. I'll just grant it. Do you have anyone else? No. Okay, both of you guys did great. Yeah, I'm granting 32. So the 4 cause challenges are 10, 14, 15, 32, and 33. You good? State?
Yes.
Okay, so Vance, you're good with that?
Yes.
Okay, so we're going to pick an alternate. We always do. So you'll get a 4th property, each of you.
So
Okay.
just to ask, did you tell me that the first for the 12, do you have to be structured in that?
I don't, no, I'm not gonna micromanage. You do what you want to do. I don't care. No. You do what you want to do. You got 4, enjoy it, but don't take too long, 5 minutes. And get them out, all right? So it's 10, 14, 15, 32, 33. Okay, ladies and gentlemen, so what's happening now is there's kind of housekeeping things that we take care of here and there. We really want to be as efficient as possible because we want to get you guys out of here. I know that time is value. So what the lawyers are doing now, they're called peremptory challenges. They're challenges that they get to make to whomever they want to for virtually any reason. There are certainly some reasons they can't strike a juror, but by the most part, you know, if you looked at them wrong, if you gave them a wrong answer, they get a couple strikes. And then after both have made their strikes, bring it up here, we reconcile it all, and then the first get picked for the panel, okay? If you give me 5 minutes, I'll try to have them done, and then we'll get you guys who are on the panel impaneled, and then the rest of you will get to go in time for lunch. So I guess, I mean, hold the number. Take a call 7. Okay.
Destruction. It is destruction. That's. It's for the real estate, the housing. Extra. Oh, that's what I was using. That's right.
Yeah. What happened?
So Judge, there's the destruction is here in the 13, and then there's the fucking one here.
No, 13 didn't get struck.
Yeah, so well, they're saying this is the strike zone, so and then all the strikes will have to be from here.
Wait, what?
So she's saying that these will be the first 6, and then the alternate will have to come from down here. So we'll be able to use 3 up here and then 1 down here, or it's just gonna be,
Just straight down.
okay. that's
Yeah,
fine.
there's no land of demarcation for anything.
Okay,
Yeah,
so I'm.
just the first 7.
Okay.
Yeah. The first 7 after all the perimeters are done.
Okay.
Yeah. While she's reconciling the lists now, here, you're gonna hear your number, your name called. If you don't mind, please coming to stand and taking a seat in the jury box. After that, you'll be sworn, and then the rest of you may leave, panel. I hope it's been a relatively not painful experience. As you've heard the abysmal numbers for jury service, I hope that you will come back and do it again. It will hopefully always be as painless and so thank you for coming again. Ready? All right, here we go.
Juror number 1, Cavazos. Juror number 2, Smith. Juror number 5, Davis. Juror number 7, Child. Juror number 8, Mohar. Juror number 9, Murphy. Juror number 12, Currington.
Okay, ladies and gentlemen of the jury, you can all definitely be here tomorrow, right? I think I've heard from all of you, so I know that you speak and understand English, which is great. Okay, if you would please rise and raise your right hand.
Do you and each of you solemnly swear or affirm that in the case of the state of Texas against the defendant, you will a true render according to the law and the evidence, so help you God?
Great. Okay, you may be seated. Thank you so much for coming. You guys are excused. I hope you have a wonderful afternoon. Go golfing, take the day off, just whatever you want. Do you have the information ready? Do you need a copy?
I have a
All right, we will now arraign the defendant. You may proceed.
In the name and by authority of the state of Texas comes now the undersigned Assistant District Attorney of Harris County, Texas, on behalf of the state of Texas and presents to the Harris County Criminal Court at law number 5 of Harris County, Texas, that in Harris County, Texas, Chelsea D. Lovey, hereinafter stop as the defendant, heretofore on or about October 1st, 2025, did then and there unlawfully operate a motor vehicle in a public place while intoxicated. It is further alleged that analysis of a specific.
Oh, are you doing breakfast? Are you about to spit out a breakfast number? Okay, but well, you don't know that yet. You don't know that yet. You can't write that out now. Yeah, but not right. If you do it now, it's gonna be a problem because it's not proven. You can do it in trial and they can use enhanced in punishment if it's found there, but not now in guilt or innocence. Every trial that we've had in the same way, I'm telling you, because you haven't proven that it's 115 above. What's your response? Yeah. You want to go to punishment. Yeah. Yeah, I mean, we can do it if we get the punishment. Then yeah, okay. All right, just hey. Just against a piece of digging this thing. Yeah.
Against peace and dignity of the state, signed Assistant District Attorney, Harris County District Attorney's Office.
Okay, to which defendant pleads.
Not guilty.
Okay, great. You may be seated. Ladies and gentlemen of the jury, we are done for today. I'm going to excuse you. We have a lot of housekeeping matters to take care of. I want to be as efficient as possible with your time. If you can come here tomorrow at 9 in the morning, as soon as all of you get here, we will go. We will try to be as efficient as possible. We give you a roadmap. I don't want to keep you here any longer than we need to. And I don't want you to sit here and wait for a couple hours today while we do housekeeping duties. And we have other business that we still have to attend to, normal court business. So I'm going to send you out. Be back tomorrow. In the interim, do not talk to anyone about this case. Do not do any independent research. Don't look at anything online. We want you to be able to come tomorrow, listen to the witnesses, look at the evidence, and make a decision at that point. Does anyone have any questions? Shoot.
Out in the hallway at 9 or?
So, yeah, we'll be at the hallway, I would say maybe 8:50, so that all you guys can get here right at 9. Deputy Etchigoin will be your point of contact. So if you ever have any issues, anyone comes to you, does anything nefarious, just let him know. We also have Deputy Williams that's also helping us out. Someone else had a question? Okay, yeah, so we'll meet here 8:50, 9 o'clock. As soon as all you get here, boom, we start and we'll go. Okay? All right, thank you so much. You may rise and we'll see you tomorrow morning.
Bye for the jury.
Before we get off the record, can I talk to you guys, the trial, real quick? Because I forgot to put something on the record. Okay. I forgot to have announcements for the record. We just went straight into board hire. So we're on the record in cause number 25. Damn it. All right, so it's 258-5617. Would you guys announce yourselves for purpose of the record state?
Shantia Shaw, Shantia, last name Shah.
Karina Batiste on behalf of the state.
Defense.
Marcia Johnson on behalf of the defense.
Kiana Sykes, also on behalf of defense.
Okay, so we went, I don't know what I was doing. I was in La La Land, I guess. We went straight into voir dire. And we had spoken prior to Ramona, our court reporter, being out here. For purposes of the record, I asked both defense and I asked both state if there were any pretrial matters, issues, limine, redactions, videos, anything that need to be talked about before we brought the jury out. Both of them said no. Is that still your contention now, state?
Yes, Judge.
No, you have no pretrial matters to discuss. Okay, defense?
Yes, Judge.
No pre-trial matters.
No.
Okay, so tomorrow morning, we'll get right. As soon as the first person, how many witnesses will you have?
4, Judge.
Do you have any witnesses? Okay, all right. Then we'll stand in recess and see you tomorrow morning at 9.
Thank you.
Okay, thanks. Good job, all you guys. It was great. Hi, you ready? Please. Bianca, you're next. Ms. Shaw, I need you real quick, if you don't mind. Hi.
I'm here on Mr. Jeffrey Holmes. Got 2 issues, Judge. One's a motion to withdraw from Mr. Ferry.
It's 9 months old, man.
No, Judge, but.
Where's the defendant
I'll
now?
let you know, he's here, Judge. I'm gonna step into this case, Judge, with this Mark's frustration. I'll step in.
Let me, I don't even have my file.
Yes, sir. Are you ready to talk about him?
Talk about that. Maybe find a deal, but I think. I think
So I said you're talking about Quintanilla. We're just. We can't get you to win that, just got business stuff, so I'll get that set up and.
Mr. Holmes, come up. Has he submitted everything to you?
Everything for County Judge was actually approved this morning, so I'm
Great.
gonna get the T-Reds done for him. And
Well,
I just want to let you know, I will step in instead of.
I mean, you're at the,
I get it, Judge. Mark, wonderful.
yeah. So if you want to file a motion to sub, then go ahead, do it. Mr. Holmes, we're going to send you for a TRAS today. It's never good to have lawyers mad at you. It never fares well for anyone. You understand?
Yes.
Right, I think that I've already had this discussion with him before. So we're going to send you for a TRAS today. Then you have 1 week to complete everything. Your case is 190 days old. We set cases for trial at 180. Next time, by the week, if you don't have everything done, I will roll you day for day until it gets done. Do you understand? Okay, we'll send it for a TRAS now and then we'll set you off about a week.
Okay, Judge.
Okay, guys, please. Bianca,
Good morning, Judge. I'm
hey,
here
thanks
on,
for, thank you for being patient. I really appreciate it.
thank you. I'm here on Cruz Ortega.
So Cruz Ortega, this case is really old.
Yes.
And she's saying that there's no rip done. What's the word, Thunderbird?
It's like we tried to reach out, Judge, 4 times, but there's been none.
So you need to eval it with no complaining witness. I mean, we can't sit here and reset it and reset it, reset it. I mean, just, what day do you want next week, Miss Amalgar?
Let's see.
I don't care.
I could do next Thursday.
It's yours. By that time, please do the rip.
Sending it back is also the felony.
I don't care about the felony. I'm not, but
But since
we-
we have the same CW, that's why.
I understand. So between now and next Thursday, reach out to the complaining or do whatever you need to do. I'm not going to tell you what to do. But, all right. So also, Ms. Amalgar, your client must be here. There are no more waived appearances for Ms. Cruz Ortega.
Yes, Judge, she is there. I believe she is today.
Okay. All right, we will bring her up and then we'll set her for that day and good luck.
Thank you.
Okay.
Just next Thursday?
Yes, next Thursday must appear bottom of page 5.
Okay.
Okay, thank you, ma'am.
Thank you,
much.
Judge. May I be
Take
excused?
care. Yes, ma'am.
Thank you.
Hi, Jakaya.
Thank you, Judge.
Good morning.
I am here on Mr. Quintanilla, Rafael.
Okay,
We were gonna ask for a trial date. It's similar to the other one. We were, it's a bar fight and making it reach the complainant and
if you want maybe like a short eval to see if they'll,
that would be great. I can come back next Thursday or Friday. We've done that.
Quintanilla. So I guess let's do the same thing. Let's set up for next Thursday. Yours isn't too terribly, we'll still waive it for the next appearance.
I may have, okay, and I'll email to see if we can work it out ahead of time, but they've got a 90-day right. We're kind of looking at it.
Well, that's between you two. I don't,
All right.
I don't want to micromanage. You do, but just be ready.
All right.
Next week, eval it without the complaining witness, see if you can go forward, and then we'll go from there.
All right.
All right.
We'll be here. Thank you.
Hi. Yeah, of course. Same thing, Hey, anything you want to talk about?
Page 3. Here,
2501 on each, on both, each.
Top of 4. It's a waste of parents. Council said, can you bring it back on the 19th? I said, yes. It's a.
Yeah, SFBF though.
Top of 12 is an arraignment. Failed to appear also has a felony of one.
Sure. 5001.
Theo?
Yeah.
Welcome up here.
You're
Okay.
Bottom of 19, set for arraignment, failed to appear.
2501.
Bottom of 20, is it required appearance, failed to appear?
5001.
Page 21, step for Raymond Felton. One case is 2 months posted.
5,002 on both, and I have to do a BO.
She and Stephen's partner. This is later on, same day when my contract is on.
I was looking at the answer, just not, maybe not yet.
Oh, yeah.
We all changed.
No. Bless you. Yeah, give me one. Let me just finish this real quick, but yeah, you come up.
I'm not touching my one very much.
Okay, I'm ready.
Hey, Judge, I'm here on Mr. Hutchinson, Wendell Hutchinson.
Okay.
Judge, at this time, I'm asking for his bond conditions to be amended. He's been having, he's had an ankle monitor device, I believe he ordered it, due to no job and no school. Mr. Hutchinson has, enlisted, to join the military. He actually showed up with his recruiter at the last court setting. He's already taking his ass back.
Show me proof.
Sure, yeah, and I just had some of this to the state, but here.
They're going to accept Mr. Hutchinson in the military?
I'm sorry, Judge?
They're going to accept him into the military? They're going to accept him in the military?
He came here with his, he came here with his recruiter to the last court setting. Let me. So this is his enlistment paperwork. And I have given this to the state as well. They have made a, sorry, Judge.
Damn, that's heavy. What the hell? That's like a brick. I'm gonna start working out just to pick up a unit. So the case is only 28 days old, right?
Yeah, so we're trying to see if we can get this resolved soon, because all that's left is for him to like do his physical and actually leave for basic training. He's always, like I said, he's already taken the ASVAB, he's already got his job lined up for him to join the military. The state did make 2 alternative offers today. One was probation, which is not logistically feasible if he does go to the military. And then the other one is essentially a time served, but.
So this is not to be interpreted as a guarantee of enlistment, as all applicants must successfully satisfy applicable enlistment standards and requirements. So he's not in it yet.
He's not in it yet, but he's already pretty much committed. He already.
Well, once he's enlisted and he's accepted, that's one thing.
I'm not sure if that document is on there, but there's a verification of enlistment document that we were also provided.
No. What exactly do you want?
Okay, so he cannot do his physical with his ankle monitor, but they're not allowing him to actually go do.
When is his physical set for? Come up. If you are really going to join the military, that's fantastic. You know, sometimes people need a little structure, a little guidance. The military will give it to you. And when you have too much time on your hands, Mr. Hutchinson, people tend to just either go out of control, become self-destructive. You have just really, it's not been a good couple of years. This will hopefully give you the guidance and structure to be as good as you can be, because that's what you should be. When is your physical set for?
I can't say anything to this case. They won't let me even do anything more than this into this case.
So I mean, then you got to work it out. I'm not going to take it off until, do you have an offer now?
We do have offers. The issue is, I'm not sure how it will actually impact if you're moving forward with.
Well, he's telling you, it's unless the thing gets dismissed, they're probably not going to accept it. The more criminal history you have, the more of a liability you become to the Army and the Navy and the Marines, and they don't want a liability.
I want to be a liability, so I'm gonna.
But actions speak louder than words, and history has a huge impact. You know, the good thing is that the more time passes between cases, people will say, okay, well, maybe this guy's matured, maybe this guy's grown up. So I'm not ready to take it off yet, because we don't even have a definitive, you know, if he gets enlisted, if they accept him, then if he gets a date for physical, then I'll take it off for the physical and then we'll put it on right afterwards. But I'm not going to just take it off with the hopes that he gets the physical, he gets it. Do you understand?
Judge, let me reconfirm with state.
You know, hopefully, you know, this will have an impact, you know.
Right, I agree.
Yeah. So, all right, take a seat, please. Hi, Lindsay.
I'm Sir Petrie, last name
Okay.
Cox.
Cox, come up.
He's here, he's right.
Oh, sorry. Good morning, Mr. Cox. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 30 days in jail with credit for the 62 days that you've done. You need to understand something very important, that by pleading guilty to this case, it will go on your record. It will be there for the rest of your natural born life. I don't know what kind of criminal history that you have, if any, but for now, by pleading guilty to this, you're looking at a minimum of 30 days in jail for any new cases that you pick up. Do you understand? If you pick up another trespass in a week, it could be a minimum of 30 days in jail from now on. Anytime, any more future cases, they can use this to enhance punishment. If you have 2 convictions, then you're looking at a minimum of 90 days in jail. You understand? Right. Not only that, if you go back to this place here where this occurred, there's a very good possibility you may be right back with us. Do you understand? It's probably a good idea not to go back. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This is final today. It can never be changed. Is this what you want to do? How do you plead to the offense of criminal trespass? Now, you also have an obstruction of a highway. I'm assuming that's going to be dismissed.
Yes, sir.
All right. How do you plead to the offense? Guilty or not guilty?
Which one?
Oh, to the trespass. All right, I will find you guilty. I'm going to sentence you to it. I'm going to follow the agreement. Good luck to you, Mr. Cox. And then the other case will be dismissed on motion. Thank you.
Yeah, I was in, I don't think I see it on here either. This one.
That's the only reason why I did it was this long.
Okay.
Let me see if they needed to sign something.
Hey, I looked at the information, I think I might have to change it in the CIC, but it already has these ones on. That's how you follow the original.
Hey, how's our boy? West.
Well, I'm about to say, which one? I got a lot of, it's doing good.
Is he still in there?
Very well.
Have we gotten any? I see that we've got 3 drug tests from him.
He's drug tested more than that, but I think when he was first getting drug tested, they weren't giving us the results with specificity. They were just like, he's negative. Because in the system, he did what's passed. And the 3 that you read, these were simply because what y'all told us.
Yeah, good. Okay. Do you know an expected release?
I think he's gonna move down to Austin in the next like week or 2 to do more of a laissez-faire treatment program.
You don't want to bring him here to resolve it, or do you have an offer to resolve it?
Yeah, I mean, there's, he said I'm docket for September 9th, and if all goes well, it's dismissed.
Okay. I hope he remains in compliance, you know?
You have what?
He remains in compliance.
Oh, yeah. I hope so too. I mean, I think.
Do we not put him on for this Friday?
Yeah. But I don't know if you still want him to be here on Saturday after you saw the drug results.
How long ago was that? Let me see.
It was like 3 to 4 days ago.
Okay, I'll move it to whatever you want, but I need to know, and pretrial needs to know the day that he's released. So, okay, so make sure that you let Veronica know.
Okay, I will.
So they need to let you know, otherwise.
They've been in contact with me almost every day, so.
Oh, really? That much?
Yeah.
Okay, good.
Melissa Malden was his treatment around, she just left and now LVR is his new one, so they're on my call.
Good.
Yeah. Okay, I saw you doing the word art. Yes.
We're pleading to the, are we pleading to the second or the first?
The first.
And they're dismissing the second,
Yes,
but it's still a second conviction, right?
yes.
Good morning, Mr. Alvarado.
Good morning.
How's jail? You know, everything we do for a reason. We don't do it just to punish and enslave. We don't do it just to be obtuse and hurtful. We do it for a reason. You have repeatedly endangered our community. And I don't know what it's going to take to get your freaking attention. Is it 10 years in prison? Is it 30 years in prison? But every single day, someone dies in our county from a DWI. And it's so flipping stupid because all you need to do, they make it so easy. A one button push on your phone and $20 will get you wherever you want to go in this life. No matter where you want to go. You understand?
Yes, President.
From now on, you're not my problem anymore. If you ever pick up another DWI, you will be in felony court looking at up to 10 years. And with your record where they see DWI, 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 if you get pulled over and an officer smells alcohol, what do you think they're going to do?
Take me.
It's a very big possibility for the rest of your life. Even if you have a sip of alcohol, I wouldn't get into a car. I don't care if you're 72, 89, they will put you in prison. There are, I don't know, 100 people doing life in prison because of a DWI. It's a damn shame. You understand?
Yes, President.
And I'm going to warn you now. You're getting on this probation now. If you test positive, that tells me that you may have an issue. I can alter and amend your bond conditions to put you in a rehab facility in the jail where you will stay for at a minimum 9 months to about a year and a half, depending on how well you respond to treatment. Do you understand?
Yes, President.
When I mean no, I mean no. Don't go to any bars. Don't go to any nightclubs. Don't go hanging out with friends because they're not the ones that are on probation. It is you. And if you violate this thing, you were looking at a year in jail. Do you understand?
Yes, President.
You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with us until you complete it successfully or it gets revoked. Is this what you want to do?
Yes, President.
The agreement you have worked out is 1 year in Harris County Jail to be probated for 18 months. As part of this agreement, you will do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions like intensive outpatient treatment, supportive outpatient treatment, you must complete it. A DWI repeat offender education class, 2 victim impact panels, no drugs, no alcohol, no breath test refusal. If you were pulled over, an officer asks you to submit a breath test, you must do it while you're on this probation. No drugs, no alcohol, you must maintain a guardian interlock. I am going to suspend your license for 1 year. I do not want you anywhere near a car. If I find that you're in a car without proper authorization from us, it's very possible we file a motion to revoke your probation and you will be looking at a year in jail. Do you understand?
Yes, President.
It's very easy. You must either get a ride. You will also be required to obtain a portable device. Can you reduce his fees to the minimum, please? And we'll give him credit. All right, Mr. Alvarado, as part of the plea bargain agreement, you're pleading guilty to this DWI. The DWI second will be dismissed on motion of the state. And good luck to you, sir. If you ever have any issues, either contact Ms. Childs, contact us, but one of the worst things that you can do is either consume alcohol, take off, or drive a car. It's really, just don't. We can talk about things, but don't just never assume anything, all right? All right, good luck, sir. All right, take care.
I also have Miss Amy O'Brien, who's the court judge, and these bond conditions.
Okay, do you mind bringing her up? What was the last name?
O'Brien.
She just get out? She just bond out? Mr. Bryant, you're charged with assault, bodily injuries. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Please.
On October 3rd, 2024, officers responded to a delayed assault call at 3000 North Loop West in Harris County, Texas. The complaining witness stated she was sitting at the hotel bar with her boyfriend, and the defendant is the complaining witness's boyfriend's ex-wife. The complaining witness stated that the defendant showed up and punched the complaining witness on the chin, causing pain. The complaining witness sent Leo's photo, or law enforcement officers, a photo of the bruise on the right side of the jaw. The incident was also captured on surveillance video.
Do we know if alcohol played a part in Ms. O'Brien's?
We do not, Judge.
No. All right. Ma'am, I'm going to find that there's probable cause as a condition of your bond. You're ordered not to have any contact with the complaining witness in this case. Your bond is already $5,002 because you have missed court multiple times. If you, it doesn't matter. Just when you have court, you have to show up. If you fail to show up, bond gets revoked and it just gets higher. Your bond is at $5,002. If you miss court again, it may triple, quadruple, or quintuple. Do you understand? At some point, someone is going to stop paying. You know, I'm paying all this good money. She keeps just, do you understand? Next time, I might put 3, 4 zeros by the end of it. We will have bond conditions created for you to sign. You're not to have any contact with the complaining witness and not to be in possession of any weapons. For now, we will have you sign a reset. We have given you a lawyer. It is your responsibility to stay in touch with her. If she tells me she cannot get a hold of you, then likewise, I will revoke your bond. There will be no more PR bonds for you. If you understand, ma'am. Okay. Do you mind filing those conditions? So no contact and no weapons?
Yes.
And then we'll get her sign a reset. And then ma'am, I'll have you take a seat in the jury box, please, after you sign the reset. Hi.
You want to judge?
Okay, ready?
Yes, sir.
Hi.
Judge, I've been off the case.
What's your cause number?
It is, cause number is 256.
Okay.
9227.
9227?
Yes, sir.
Okay. Oh, I remember this one. This is the nurse from out of town.
Yes, sir.
And this one's still going on? It's been over a year.
Unfortunately, she's been kicked out of the TI program. So the case is set to be back on docket as of right now, August 21st.
She's got to be here.
I
If she wants to come earlier, she can come earlier, but she's got to be here to resolve it. She's either got to accept the plea bargain agreement or we're taking it for trial. I mean, it's over a year. I'm not going to keep continuing. She's a flight attendant. She can make it over here. I'm sure she can. So
Is it possible that we can move that to September 14th? She answered the current assignment she's on.
she's not in compliance. I don't know what the heck she's doing. She could be out boozing up like crazy and we would never even know it. You know, she's just not in compliance. And I have had so many bond violations with her that I just don't trust her. if I had someone who had no bond violations and then perhaps, but with her, it's been nothing but issue after issue after issue after issue, you know? I'm happy to put it sooner, but she's got to be here, man. I don't know what the heck's going on with her, okay? Sorry. You too. Take care. Hey, bud.
I just have some Joe's instructions for, Miss Woodrow, just so Joe and Andrew confirm there's a violation.
Okay, I'll sign it for you. Thanks, Sebastian.
The other way.
Do you know how to file conditions?
Judge, Karina told me that I just send them to her and then she'll file.
She'll file them?
Yeah.
Okay. Got it.
But I'm writing down her consent.
Okay. On her, can you file no weapons, no contact? That's, what was your last name again?
That's O'Brien, Judge.
Oh, Brian, that's right. Hi, Willie.
Judge, how are you?
Come on up. What's new, man?
Judge, I've got off docket. I wanted to approach and I apologize. I should have done it the other day when I was in court.
Don't, it's fine. Don't worry. What's your cause number? Yeah.
What do I? 2627493.
On a Martinez.
Yep.
Okay.
So here's my request. So Gustavo has an interlock system on now as condition of response. Gustavo has a CDL and works as a truck driver, which he hasn't been able to do. Spoke with the state, they're not objecting to it if you consider this. He put a scram device on in place of the interlock so he can maintain employment while I try to hash this out. He's got prior criminal history, old, that's a felony conviction. I'm gonna take a run at a divert on this. Because my position with these guys, it's not an egregious DWI. What I respect about my client and this, when guys go to prison at a young age, they come out, they're gonna go one of two ways. They're either gonna learn and hone in and become a better criminal in prison, or they're actually gonna get rehabilitated, come out and try to do something, better with their lives. Which
What would you say is this one?
I think he's got CDL as a truck driver.
Yeah, but he's got a felon in possession conviction from last year.
I know, but that's, because he had a good. I know, it's a long shot at it, but I'm gonna take a run at it.
Does he have any prior DWIs?
I don't believe so.
I'd like to do a full NCIC. Do you have access?
This isn't Mr. Martinez, is it?
Yeah. I don't know. He's our first day here.
I mean, he's okay with.
But that doesn't stop the car in the event that he has alcohol on him. That's my, and if he's driving a 15,000-pound car,
But I get that.
that's an issue.
I know, but he can't put them on the trucks. And it doesn't stop him from, what it does is, it doesn't stop him from wanting to just put it on his personal vehicle and then drive in these rings anyway.
Well, I'll just put him in jail if he does it. Really, we're not asking for much, but hey, Karina,
Yes, sir.
can I give you a cause number?
This for his judge?
Yeah. Can you run an NCIC? Does he have any prior DWIs other than this one
No prior DWIs that I saw, Judge.
from anywhere? So you're okay with him a scram?
Scram's better than interlocks on the seat, because that's on the go.
But the only problem is the interlock kills the car if you have any alcohol on board. That's my only issue. Whereas if
I
he,
mean, we're talking about it, Judge, and the fact that he's able to get a job and has a CDL, I don't know that for him.
well, we don't know that he has a job.
He does. Well, I mean, I know you're taking my word for it, but I know he's got a job. I mean, I can provide proof of that as part of it. But that's, the fact that he's driving trucks doesn't concern me.
Do that and I will acquiesce to you. So he's gonna have to come to get the scram on.
Yes, sir.
So when he comes here,
Yes, sir.
have him, Veronica left already? Or she didn't make it again?
No, she'll go to another court for short
Oh,
staff.
okay. Just come back.
You don't have the control of your court the way I thought. The people who work for you just seem to be.
Whatever, but just there's so much attrition and just the turnover is just disgusting.
Turnover's crazy.
Yeah, that's what I'm, everywhere. Prior to, all we had was,
I know, because I was helping them out.
So I'm okay with it. All I want is proof that he's working. Let's have his work schedule. I don't want him out in the middle of the night. We'll put a scram on him and then, okay.
Fair enough, Judge. I'm
Yeah.
leaving town Friday. I won't be able to be here. May I have him,
I don't, it's up to you. I don't care.
may I have him report and ask to speak to pretrial and give that information?
Yeah, sure.
They'll probably come to you and.
Yeah.
Okay,
Yeah.
I'll have them bring that information.
Okay.
All right, thanks, man.
So proof that he's working.
Yes, sir.
I just don't want him out in the middle of the night
I get that.
and then the scram.
Yes, sir.
And then, do you think they should put it on a personal or no?
I'm sorry, Judge.
On his guy?
But you should put,
Because the thing is that he can't put it on the work truck. We can still put it on a,
Well, if it's a scram judge, it's okay.
Yeah, I mean.
I know.
But he's asking if we should put an interlock on plus.
personal.
Judge, I would ask from a financial perspective unless you.
I'm gonna pay for it anyways.
Well, I wasn't asking. you to.
We pay for everything.
Yeah, I mean, he's already got he's already got that on. So if you want to leave that on.
On his personal vehicle?
He's got an interlock on.
Okay, cool. Yeah, let's do it. I'll pay for everything regardless.
Yeah, he's got an interlock.
Okay,
All right.
thanks, Willie.
May I excuse-
You got it, man.
Good to see you.
Have fun. You too.
Oh, I will.
I know you will. Are you ready?
Yes, Sean.
Hi.
Of course, I'm all for
For jail or bond?
Bond.
AL, oh. Okay,
It's all for next two cases, so assault, bodily injury, kind of old,
another assault.
and then assault family member.
Yeah.
I can, talk to the state about some, for PTI to resolve both of those cases. She's not quite there yet, so I have a little work, and so we're just asking for some time to do that.
So our case here is 8 months old. The oldest one. So
I think one of them was a 2B judge. Yeah, it was a 2B judge.
which one is the 2B?
The old one, the ABI. My understanding is a 2B and she didn't get a reference, so she picked up the new law lightly.
She made a cash bond in May, right?
Yes.
Okay, all right, we'll give you a normal reset. Just remind me so I don't blow gasket every time, okay? Because if I don't see that there was a 2B, like I'm going to assume that she's been on bond since January. So just remind me, just a normal reset. Yeah.
one of them, the cash bond was posted in 2025. So one of them is actually.
She had bond in 2025.
Oh, it is from 2025.
Oh.
Yeah, that's the ABI. I thought she was a 2B.
Yeah, that was.
No. She posted a bond. She just took off in the next month and she's been MIA. So let's do this. I'll give you a week. It's over a year old, man. It's a year and a half old. So I'll give you a week. She's got to have it done. Tell her if she doesn't have it done. She's got to be here.
No problem.
Okay? All right. Sorry. Thank you, Victoria.
Judge, was that a PTI?
I think he's applying. Yeah.
Applying.
Yeah, because everything's complete, Judge, in regards. to
Discovery on both?
Yeah, there's everything's complete on both.
Okay.
I'm just gonna do a follow-up rip on the old complaint since it's been so long, but we.
Okay.
So.
Hi. Come on.
All right, which day next week? I'm here on this.
It's jail? Okay. Oh, it's a new case. I wonder why she didn't make bond. You see?
Had a reason bone, but she also has an ISO.
Oh, okay. Did you get appointed or you retained on it? Okay. What would you like? So essentially, I don't know if you can't get an immigration bond to get her out. That's something that you guys will have to do, either hire an immigration lawyer or you guys go to immigration court to see if you can get an immigration bond to get her out. If you're unable to, then she's just basically in there until you guys resolve the case by either plea or trial. So essentially, we're basically at your mercy as to what you want to do. We can set it a week, 2 weeks, a month, and then just, I guess, go back, talk with the family with what you want to do. I would say maybe at least maybe 2 weeks to give you time to get the evidence, let her know, hey, these are your options. And I don't know what kind of resources the family has. So, but
We don't do any immigration at all.
it's probably a good idea also to have an immigration consult because whatever this is could. So just out of an abundance of caution so that you know as well. So yeah, you just pick whatever day you want. I'm cool with it. Yeah. And then in the event that she does bond out or if she does get an immigration bond, we need to let us know. If you guys post this bond now, it's very possible that they send her to immigration. So, yeah. Okay.
Thank you.
Yes, ma'am. Thanks.
Yeah.
Oh, yeah, that's what he moved. Yeah. You have
What he came for that, there's a Spanish one that has one of the schools that you have to share. I just sent it, you know, no worries. I never know because I don't.
Hi.
I was told that there was somebody that came in about an amended condition act.
Let me give you the cause number. It is 262-7493 on a Gustavo Martinez. I don't want you to do anything yet. So allegedly, he drives trucks for a living, but I want proof that he's actually working. So the lawyer said he's going out of town, so the defendant might come here. So we need proof of employment, number one. If there's proof of employment, then he will get a scram on his ankle. He can only drive the truck without the interlock, as long as the scram is operational. He must maintain the interlock on his personal vehicle. And then I do not want him out in the middle of the night. So we'll look at his work schedule and we'll tweak it. But if he's driving, he's not going to be driving in the middle of the night. I'm not going to allow a 15,000-pound missile at 1 a.m. when I don't have a device on the car and you've got a DVI. It's not going to happen. So I may have to give him a GPS monitor. We'll see. Okay. Anyone else? Yeah, so he took a drug test last week and it seems like it was fine. So I'm not going to put him on for Friday. I let her pick another day. The problem is that she said that he's probably going to be released sometime soon. And then he's going to Austin. I told Ms. Childs that we need to know the day that he gets out so we know about the device on his ankle. So he's not out in the middle of the night as well. So in the event that he doesn't contact us or she doesn't let us know, then another BVR needs to get filed with that info. And then at that point, we'll have a bond hearing. Okay. That's it. Duncan, we put on the docket because he didn't sign bond conditions. That was today or is that tomorrow? Tomorrow, okay. Okay, thank you.
Judge, the one Mr. Bell approached you on, she goes up here, are we doing an SFPF setting or?
I didn't know that she was supposed to be here.
Yeah, she was a part of today.
He didn't?
That's why he didn't get approached. She called and said she was in the ER, which way?
We put it on for next week, right?
Yeah.
Just put it on for next week.
But
But no, but document today that she failed to appear when she was supposed to be here. So if she fails to appear next week, guys, I think we're done. Yeah,
Judge, I have a question.
shoot.
If I provide case law in regards to my argument that I made earlier,
It's too late now. I don't know. I don't, let's not talk about it till defense gets here.
I'm gonna email them and I'll email you.
Email them, tell them what you're trying to do, and then we'll have a hearing over tomorrow morning. My experience has always been the other though. Because I mean,
O'Brien,